Okay, section 66 and 71, I've just summarized here. You have to have a certain number of directors depending on what type of company you have. So private has to have at least one, public at least 3. Profit company, excluding estate owned, needs to have at least 50% of the directors appointed by the shareholders. So your shareholders should be appointing your directors. Okay, if a person is ineligible or disqualified, the election is void. They can't be elected, and that's going to be covered now in section 69. Special resolution must be passed within 2 years for directors' remuneration. So just to say that there is an expiry on that. Okay, eventually after 2 years they're going to have to get a new resolution for the next remuneration for your directors. And then 71, which is deciding on the removal of a director. The removal can be done by an ordinary resolution of your shareholders, or if the board can prove that the director was ineligible or disqualified or incapacitated or neglected his functions, then the board can actually remove a director. Okay, but only under these circumstances for the board of directors to remove, whereas with an ordinary resolution of the shareholders for any reason that they would like to remove a director. Okay, quickly, 66. Okay, you can see it actually tells you 1 for private, 3 for public or non-profit. Okay, and then it talks about how profit, at least 50% of the directors should be elected by shareholders, but ultimately, guys, we'll see now that all directors should be appointed by shareholders, and their remuneration is authorized by a special resolution. Okay, 71, removal. Director can be removed for any reason by an ordinary resolution. So remember, then you're going to have to say if you have to audit it, inspect the notice, 10 days or 15 days. Inspect the quorum, 25% and 3 people. And then inspect the resolution, more than 50% of the voting rights present, voting in favor of the removal. Okay, what happens here? The process is that there will be notice given to the director, and he will be given time to present his case. Okay, and then they will vote. Okay, if they've got more than 2 directors and they believe that a director is ineligible or incapacitated or neglected his duties, the board can remove this person. And again, the board has to follow the same process as the shareholders, give the director notice and give him an opportunity to make representation as to why he shouldn't be removed. And then the director may apply within 20 business days to the court to review the decision to remove him if he doesn't believe that it's a valid decision. Ineligibility and disqualification of persons from being directors. So guys, in a question you see that a director is a company or a partnership, is a juristic person, it can't be. Or the director is a minor who is still represented by his parents. That's what unemancipated means. His parents are still in control of him. Or there was a criteria in the Memorandum of Incorporation that said these people cannot be directors if they don't have these kind of criteria, and this person doesn't have that, he's ineligible. As soon as somebody is ineligible and they're elected, they need to be removed because they are ineligible. Somebody could have been disqualified, so they may have started out as a normal candidates and then done something to disqualify them. So if they were declared a delinquent by the court, and a current example is Dudu Mnyeni from SAA, the former chairman, or they were an unrehabilitated insolvent, or they've been prohibited in terms of any public regulation, removed from office of trust due to misconduct, or convicted and imprisoned without the option of fine, then he's disqualified. So either of these people should not be directors. And if the board feel that somebody meets this, the board can then request removal. And there you'll see it in section 69. Ineligible listed here under the 3 points for 7. Disqualification listed here under the points for 8. Okay, section 72, board committees, and then I've added regulation 43, which is the social and ethics committee, because the Companies Act says that the board can have any number of committees as they feel fair, and they don't even have to have directors on those committees. So they could have people who aren't directors that are on the committee, they just cannot vote. They must appoint a social and ethics committee if it's state-owned, or they are listed, or their public interest score is more than 500 in any 2 out of the 5 previous years. Okay, so remember we said where we saw that they were a public company in the background information, I straight away said they need to have an audit committee, external auditors, and a company secretary. Now when you see that they are listed, it has to have all of those criteria because only public companies can be listed, and now you should add social and ethics committee. And whenever you see you should be working out the public interest score, or you see they have that information in the question, revenue, shareholders, employees, loans, those were all the criteria to working out the public interest score. And you start to see that, you start to think, why do I do the public interest score? Either to see if they need to be audited, or to see if they need to have a social and ethics committee. Different criteria for social and ethics committee. Any 2 out of the 5 previous years, the public interest score was greater than 500. So now we're not looking at the 350 or 100 criteria. And then they just tell you what needs to be in that social and ethics committee. These 3 directors and 1 must be non-executive. Okay, we'll see this again when we get to King. Okay, and there's your board committees there. It deals with the social and ethics committee by referring you to the public interest score. It doesn't give you the amount here. So for that calculation, the 500, you need to be looking at the regulation. Okay. Section 73, board meetings and directors acting at other meetings. So I'm just going to really discuss the board meetings, because directors acting at other meetings is just saying they can actually do board meetings electronically. So what happens? Exactly the same thing as your shareholders, although the criteria differ. So they also have to have notice for their meetings. They just don't specify. Like in your shareholders, they say 10 and 15 days. Here they just say there must be notice. They have to have a quorum. Here the quorum is majority must be present. So unlike your shareholders where it was 25% of the voting rights, now it's more than 50% of the actual people, because each director has 1 vote. Okay, they don't have percentage votes like your shareholders do attached to the number of shares they have. So majority must be present, and then majority must pass the decision. Okay, so again, if we're saying that they've got 10 directors, then 6 must be present for a quorum, and then 4 have to vote in favor for the decision to be passed, because we've got majority present, but then it is majority present must vote in favor, not majority of directors must vote in favor. Okay, so just add that here. Okay, same criteria. If you have to audit a director's decision, go and inspect the minutes for the notice, go and inspect the quorum to see that more than 50% of the directors were there, and then inspect the decision that more than 50% that were present voted in favor of the decision. Okay, and then you'll see there who can call board meetings, so you can see that any director can, and they must call if at least 25% of the directors ask for it, or 2 directors in any other case. Okay, there you can see they discuss the notice, and they say that the notice is in the memorandum of incorporation, so each company will have its own. Then it talks about majority must be present. Each director has 1 vote. Majority must vote on the resolution to approve it. Then, very NB section, hence the NB's up there. Section 75, director's personal financial interest. So this is where any director has an interest, whether it be financial, whether it be a relationship, affecting a decision that is going to be passed. So they've got some sort of an interest in this decision. If they have an interest in a decision, they really shouldn't be involved in the making that decision, because they have a conflict of interest. Do they do what's best for the company? Do they do what's best for them? They have to do what's best for the company based on their obligation as a director. So, what do they have to do in this case? They have to disclose their interest and the general nature and any material information before the meeting takes place. If they are present, they need to leave the meeting. They must not take part in the consideration of the matter. While they are absent, they are present in terms of a quorum because they were at the meeting, but not for the vote. So they don't get to add in an extra vote for that decision. And they cannot execute any documentation on behalf of the company for this matter. So guys, generally you would put down, they need to disclose the interest and the general nature as 2 separate points. They must leave as another. They must not take part in the consideration as another. They will be regarded as present for the quorum, but not for the vote as another, and they shall not execute documentation. So 6 points for putting down the requirements of directors' personal financial interest. The hardest part here is identifying this section. Okay. Note that if the director didn't disclose, did take part in the vote, and the decision was made in favor of what he wanted, the decision still stands if and only if it was subsequently approved by shareholders with an ordinary resolution, or if it was declared valid by the court. If it's not declared valid by the court, or an ordinary resolution was not passed by the shareholders authorizing it, the decision is not valid because they contravened Section 75. Okay, so you're looking for anything when there is the director's financial interest. When they want to give a loan to a director, you've got the Section 45 criteria and now Section 75. He should not be involved in this decision. When a director wants to, or when the business is looking at finding a supplier and the director's wife is a viable supplier, there's a director's interest in contract unless he discloses and doesn't take part in that decision. Okay, so there it is in Section 75. Tells you who we're looking at in terms of directors, and it then also says related. So if it's any director or somebody related to a director that is going to be affected by this decision, it is director's personal financial interest. Okay, just note that this is not relevant if the decision affects all directors, because then nobody can be present at the meeting, or if it is specific to a class of share that a director has a share in. Alright, and then how do they go about it? He needs to disclose his interest, disclose material information, any observations. If he's present, he must leave, must not take part in the consideration. While he's absent, he's regarded as being present for quorum purposes, but not for resolution purposes. So he doesn't get to have any say in the vote, and he can't execute any documentation. Okay, and then they talk about how it could be subsequently ratified. Okay, ordinary resolution by your shareholders, or if the court declares it valid. Okay, quickly, standard of directors' conduct. I've asked you to just put down here a couple of bullet points. How do you think directors should act or conduct their business? They need to obviously act in good faith. They need to act in the best interest of the company. They need to act with a degree of care and skill. They must not use their position to gain advantage. At the expense of the company. Okay, you can think of any other valid conduct you would expect of your directors. Just do note that they will be liable if they breach this fiduciary duty, which is to act in a specific way. Okay, and if you go to 76, you'll see everything there. Okay, mustn't gain advantage, knowingly harm the business. They must act in good faith, best interest, degree of care and skill. And yeah. And finally, Section 214, false statements, reckless conduct, and non-compliance. So a person who's found guilty of any of these could be held liable for losses. Okay, so just to be aware, when you see that the directors are being associated with or actually creating fraudulent financials, therefore being associated with fraudulent financials, you've got non-compliance with Section 214. Okay, let's look at this last class question, guys. I'm going to give you, again, 5 minutes for this.